Let's get started then. Hello, and thank you for attending this webinar on common obstacles when representing Afghans. This webinar is hosted by the American Bar Association's Commission on Immigration. So let's move to the next slide. Today's webinar is going to draw from the practice advisory produced by the ABA Commission on Immigration, the Catholic Legal Immigration Network, Conklin Immigration Law, LLC, and the clinical program at Trinity Law School. Some of the contributors to this work are panelists on today's webinar and include Reena Arya, the Director of Immigration Legal Services at Jewish Family and Community Services of the East Bay, Elizabeth Carlson, Senior Attorney at the Catholic Legal Immigration Network, Lance Conklin, Adjunct Professor from Trinity Law School, who also runs his own firm, Conklin Immigration Law, LLC, and myself, Dina Sharouk, Senior Legal Advisor to the ABA Commission on Immigration. Now, in the wake of the Taliban's resurgence and takeover of Afghanistan in 2021, the United States offered pathways for the limited amount of Afghans who were able to make it to the United States to remain here. This includes parole under the Operation Allies Welcome, or OAW program, as well as temporary protected status, or TPS, for Afghans. But these measures offer temporary status in the United States for individuals fleeing a humanitarian crisis of an unknowable duration. Many Afghans who have made it to the US will qualify for asylum or other forms of long-term protection, but they're likely to be thoroughly scrutinized through the lens of the bars to asylum that could render them ineligible. We, along with practitioners in the field, have observed the practical obstacles that Afghans face in seeking protection in the United States and devised this practice advisory in order to help practitioners navigate the complexities of Afghan humanitarian immigration claims broadly, but specifically today we will focus on asylum seekers. So right there you'll see the QR code for the practice advisory. We encourage you to also, if you're unable to find that QR code later, you can also find this this publication on the publications page of the ABA Commission on Immigration. And it is linked here on the slide. What we cover today is only a small part of the rich content and resources that is included in this practice advisory. So we can move on to the next slide. During today's webinar, we will begin by discussing the Persecutor Bar and the terrorism-related inadmissibility grounds, or the TRIG bar, the firm Resettlement Bar, and serious non-political crimes. Finally, we will dedicate a portion of the webinar to answering your questions. As a matter of housekeeping, if you have a question, you may submit it through the Q&A function on your screen. Some questions may be answered in written form, and some questions will be selected for our panelists to answer live. And with that, I will turn it over to Reena to discuss TRIG.
Thank you, Dina. Hi, everybody. Welcome today to talk to our webinar on pretty much the bars to asylum in Afghan cases. I'm going to start us off with the terrorism-related inadmissibility grounds, otherwise known as TRIG. The TRIG bar has a long history, unfortunately, within the last probably 23 years, as applied to asylum seekers. Today, we're going to discuss just generally what the TRIG bar is and the specific exemptions that have been created to specifically only apply to Afghan asylum cases. But before we get to the specific exemptions, I thought we could just go over the statute a little bit together today, because it is a complicated statute. All of the bars to asylum can be pretty complicated, which is why we put together this practice advisory. So if you have any questions about some of the material in the TRIG bar portion of the presentation today, please, refer to our practice advisory or ask us any questions. But with that, let's talk about the main part of the statute where we get our where we get our information regarding the TRIG bar. We start with the statute. It's at INA 212A3B. So asylum and withholding applicants are generally not subject to the inadmissibility grounds, as you know, whereas other forms of relief with immigration are subject to the inadmissibility grounds, such as adjustment of status. However, asylum seekers are subject to these so-called terrorism-related inadmissibility grounds under INA 212A3B. And these grounds are also included as mandatory bars, and there's a cross-reference in the asylum statute at INA 208. The TRIG bars also are located in the deportability grounds at 237A, which is on the slide. The TRIG bars are kind of a complicated array of rules and interconnected statutes and definitions, and the government has been known to interpret the statute quite broadly. In Afghan cases, because there's a long history of insurgent fighters in Afghanistan, and because the U.S. had designated the Taliban as a terrorist organization, it's crucial for advocates who are representing asylum seekers to understand the TRIG bar. Now, as I mentioned, 212A and INA 237A contain the bars to asylum based on terrorism and inadmissibility grounds. So on the top of the screen, you see has engaged in terrorist activity, engaged or incited in terrorist activity. We'll talk a little bit about what that means, and that's probably the most important part of the TRIG bar. The second part is whether or not a consular officer, the DOJ, DHS knows or has reasonable grounds to believe that a person has engaged in or is likely to engage in terrorist activity. Any kind of indication or intention current to engage in terrorist activity, current membership in a tier 1 or a tier 2 organization, and current membership in a tier 3 organization. Now on the slide, we have the different tiers, tier 1, tier 2, and tier 3. I wasn't going to actually go into the tier designation in today's presentation. It's not necessarily complicated, but I invite you to look at the practice advisory to kind of get some sort of background. But the Taliban has been designated as a tier 1 organization, which means that they're an organization that the United States believes is a terrorist organization. There's a slight difference between tier 1 and tier 2. These are designated organizations you can find on the Department of State website, so you know who's in tier 1 and you know who's in tier 2. Tier 3 organizations tend not to be subject to publication on any government website, and so we don't necessarily know which organizations are a tier 3 organization. But there is some discussion of that in our practice advisory, so I invite you to look at that. Okay. And then there is endorses or espouses terrorist activity or persuades others. So that's recruitment generally, receiving any type of military training on behalf of a terrorist organization. So that's another thing to think about with our Afghan cases. If anybody was ever in the military, or if anyone has ever received any kind of military training by the Taliban, Al-Qaeda, or any other organization that has been active in hostilities in Afghanistan. Next slide, please. So what I had mentioned before was engaged in terrorist activity. And what does that mean? It has a very, very broad definition, engaging in terrorist activity. But within that definition of engaging in terrorist activity, you have the quote, which is at the top of the screen. A person who affords material support for the commission of terrorist activity to a terrorist organization. The terms material support, two very small words, have been are the most commonly applied portion of the TRIG bar, and in many ways can be considered the most broad. The material support provision is part of the definition, like I mentioned, of engaging in terrorist activity, which you saw on the slide before. And it can include a lot of things. It can include providing safe house, transportation, communication, funds, transfer of funds, any kind of material, financial benefit, documentation, weapons, etc. The list is not exhaustive, and the statute is very clear that the list is not exhaustive, and the government has interpreted this particular definition quite broadly. For instance, USCIS and courts have found that providing funds, including things like ransom payments to secure freedom of kidnapped family members, as well as payments to pass through checkpoints on a road, to be considered material support. They're considered material support because of the transfer of funds. And I will talk a little bit on the next slide about amount. But again, the practice advisory goes a little bit more into depth with regard to the amount of material support. And the government also considers that merchants who sell things to terrorist or terrorist organizations to have provided material support to terrorist groups or to terrorists. Even though one may assume that earning money from their customers, they don't necessarily have a choice, or maybe they don't know that they have been selling goods to terrorist organizations. So again, there is, there on the slide, there is some consideration for knowledge, whether or not there was knowledge with regard to, is the group a terrorist organization? Did they know that they were funding a terrorist organization? That can be considered an exception to the rule, not necessarily an exemption, but that's also very fact specific, and there is some case law around that. And again, there's a lot of explanation of that in our practice advisory. The amount of support, de minimis, is usually not enough. So we can't make the argument that it was a very small amount of money. We have to make the argument that the amount of money that was given didn't affect the overall functioning of the organization. And again, intent is also irrelevant. So let's talk a little bit about exemptions and exceptions. We don't have a whole lot of time to go into TRIG, but let's talk about the exemptions and exceptions. Now, there are two types of exemptions. There are the group-based exemptions and the situational-based exemptions. Now, the situational-based exemptions are ones which is obvious, certain situations. USCIS is the only agency that can designate the exemptions, and they're on the USCIS website. And listed on the slide, except for the second bullet point, are the situational based exemptions. There are exactly 4 that apply to Afghan asylum cases, and we'll talk a little bit about those. But duress is an exemption. Was there duress with regard to the material support? Did somebody pass a checkpoint, and were they did they feel duress when they had to give money to a terrorist organization, for military training, for solicitation? Those are our 3 main parts of the statute where the duress exemption actually applies. Voluntary activity, such as medical care, this exemption came around during the conflict in Syria and in Iraq. A lot of doctors were giving medical care regardless of who the patients were and on what side of the conflict the patients came from. So there's an exemption, a situational exemption for voluntary activities such as medical care. Iraqi uprisings, again, this exemption came around during the Iraq War in the beginning, in the early days where the Iraqi forces, there were a lot of Iraqi uprisings against Saddam Hussein's regime. And then we get to Afghan civil service, Afghan allies, certain limited material support, and insignificant material support. Certain limited material support and insignificant material support I'll talk about in just a second. But I want to talk a little bit about exceptions. There is an exception, I would say a very narrow exception called the lack of knowledge exception. One would have to demonstrate clear and convincing evidence that they didn't know or reasonably should not have known that that they were providing material support to a tier 3 group for either membership, solicitation, or material support. And in some cases, the argument can be made that they gave material support under duress to a tier 1 or a tier 2 organization as well. And the practice advisory talks a little bit more about the exceptions, but the lack of knowledge exception is one that is functional with regard to getting out of this getting your client out of being barred under this, under the TRIG grounds. Next slide. So an exemption, what is an exemption? And an exemption allows basically USCIS to say that the TRIG bar does not apply to your client. It doesn't have to be a complicated process. There's basically a worksheet. The asylum officer fills out the worksheet and says that this exemption, which you will find on the USCIS website, does not apply to your client, and why it does not apply to your client. So I think this was back in 2014. This particular exemption came out: certain limited material or insignificant support. There are actually two exemptions. And so what is certain limited material support? And this necessarily, there's certain things that fall within this exemption: routine commercial transactions, routine social transactions, humanitarian assistance, and something that is now called sub-duress pressure. Now, if you remember on the prior slide, I had duress, just general duress, as an exemption for material support. Sub-duress pressure is supposed to be considered less than normal duress pressure, and it falls within this particular exemption category. It's very helpful. Maybe the person who was threatening your client didn't actually have a gun, and it doesn't, maybe they didn't feel like they were going to imminently be harmed, but there is a duress pressure, a sub-duress pressure that could be argued that every time you pass through a checkpoint, even though the person doesn't have a gun to your head, you feel duress and you have to give money to pass through the checkpoint. So the sub-duress pressure was a welcome change with this particular exemption. Routine commercial transactions generally means a transaction a person could or would engage in with any individual considered in the ordinary course of their business. And so what does that mean? It's substantially the same terms as other transactions, regardless of the parties to the transaction. And the transaction was consistent with established practice. So a store, you open a store and you're selling cell phones, and you sell a cell phone to someone who's a member of a tier 1, tier 2, or a tier 3 organization. You sell cell phones, you sold them a cell phone. If they walk into the store and you sell cell phones, and then someone from a terrorist organization comes in and you sell them a gun, well, then that's not a routine commercial transaction, and the exemption probably wouldn't apply. Routine social transactions, for the purposes of this exemption, the phrase usually means a transaction that both satisfies and is motivated by a specific, compelling, and well-established family, social, or cultural obligation: attending a party or a religious gathering, or giving someone a drink at a religious gathering. So if there's a religious gathering and it's a routine religious gathering, not one in order to raise money to have some sort of, terrorist activity or something that someone would presume to be a terrorist activity, that wouldn't be a routine social transaction. But a normal transaction where there's a religious gathering and you offer somebody a drink or some food, that would be routine and that would be exempted. I could also go into humanitarian assistance, but that I think speaks for itself. Any aid provided for the purpose of saving lives or alleviating suffering would be considered exempted. And like I spoke a little bit about sub-duress pressure as well. It generally means a reasonably perceived threat of physical or economic harm, not necessarily the pressure that would meet the definition of duress pressure, which is more imminent. So I just want to talk a little bit on the next slide on insignificant material support. This one is considered minimal in amount and inconsequential in effect. And this is not a duress exemption. It's basically giving a little bit of something to someone from an organization that is a tier 1, tier 2, or tier 3 organization. And I put an example on the slide, and I can read it out. Amina was at her home located on the outskirts of Kabul when 3 members of the Taliban came to her house and asked for a glass of water. They were not carrying weapons and she did not feel pressure. Nevertheless, she believes in helping people, so she gave them a glass of water and they were on their way. Without this exemption, there's technically there would have been a probability that Amina would have been TRIG barred for giving a glass of water to the Taliban. But in this situation, if she could argue that this was a minimal in amount and inconsequential in effect, meaning she wasn't trying to save their lives, they weren't dying of thirst, she just gave them a glass of water, this exemption should apply. And I want to go through the last two exemptions. Afghan civil servants. Next slide. Many individuals who worked for the civil service positions in Afghanistan before September 27th, 1996, and continued to do so after that date. Many did so under duress or in situations of hardship. In other instances, individuals use their positions in their humanitarian capacities to mitigate the repressive actions of the Taliban, and often they did so at very great personal risk. So these civil servants subsequently worked for and gave assistance, for the ISAF, the U.S. government, the Afghan government, which was established in December of 2021. And some individuals continue to provide essential government services even after the fall of Kabul in August of 2021. So working for the Taliban regime can be exempted. Some of our clients did work for the Afghan government after the fall of the Taliban in 2001. However, many were in the employ before that. So in 96 to 2001, when the Taliban wasn't in power, but considered a terrorist organization. So if you have clients in this situation, you want to think about this exemption. I'm pretty sure USCIS will automatically apply this exemption for Afghan civil servants. And then finally, we get to Afghan allies. So some adjudicators apply this exemption. They need to determine whether or not the person's activities were directed against the Soviet Army, the Taliban, or any of its affiliated organizations, or other insurgent groups actively involved in attacks on the Afghan Transitional Authority or the government of Afghanistan or any of the international allies, such as the United States, the ISAF, or any other NATO-led organizations. And if so, they could be exempt for their participation. The exemption applies to attacking groups who are attacking the U.S. interests, or any U.S. supported groups before the Taliban takeover in August of 2021. And so just to remember, as you probably know, the Afghan government was Soviet-backed between 78 and 92. So this could mean the Mujahideen members will be exempted during this time period. And so I just wanted to make clear in these situations that dates are very, very important for the exemptions to apply. And I'm sure many of you have gone to asylum interviews where if these issues have come up for older Afghan clients, were you a member of an armed force, an armed group? Did you take up arms against the Soviet Union, etc.? Dates are going to be extremely important to see if they can apply this exemption. And I know I've gone over time, so I'm going to quickly go over two examples. Ahmed and his family are from Herat. In 2010, following the bombing of his town, he and his family fled to Kabul. En route, they were stopped by the Taliban, who told them to pay money to pass through a checkpoint. This is very common. In fact, this is very common in 2001 as well. He might have to argue that he was under duress when he gave the money to the Taliban. Or he may be able to argue the sub-duress pressure as well. And finally, the next one I have is Jasper from Kabul. While working for a telecom company, his friend asked him to tap a phone line. He did this for his friend, but later found out that the person he spied on was arrested by the Taliban. Now, let's say that this happened while the Taliban was in power. It could have happened before the Taliban was in power, when the Taliban was a tier 1 terrorist organization. He could have the knowledge exception in this case. Did he know what he was doing? Did he know that the people were going to be harmed by a tier 1 terrorist organization, which is the Taliban? So in these types of situations, if your clients mention that, eventually they found out that they were giving support to a terrorist organization, you want to find out if they knew about it, and you might be able to make a knowledge exception. It's a very not narrow exception. In our practice advisory, we discuss this exception a little bit more in detail and the case law that surrounds it. And with that, I will turn this over to our next panelist, Lance Conklin, to go over another very important bar, the Persecutor Bar.
Thank you, Reena. Just want to welcome you all here. Thank you for coming today. And just really, I'm talking about the Persecutor Bar. And partly this is, I want to say, somewhat personal because I'm a veteran. And I think one of the things that really touched on is a lot of the Afghans coming here, military personnel who supported us for 20 years. And I was really concerned with some of the language we were hearing out of the asylum office about the Persecutor Bar. And I really feel like some of it is a little bit knee-jerk responses. And I wanted to do all I could to try to help people. And plus, I actually was reminded my very first case in asylum law. I had been sworn in maybe 2 weeks. It was a removal case on asylum. And 10 minutes into my case, the judge turns to him, starts asking him questions. He started talking about a story that I never knew about, how he stood outside while this from Guatemala, rebels had gone in and killed somebody. And, in a matter of 10 minutes, my case just evaporated, didn't know what to do. So I kind of, it's interesting. I've dealt with the Persecutor Bar going way back to my beginning. This is that was 1996. Much more interesting. More about that story. Maybe I can share it at another time. One thing I wanted to mention, I really from the Persecutor Bar, the frustrating thing about this is it's very, there's not a whole lot of wiggle room if someone is found to have subject to the Persecutor Bar. So in a lot of ways, it's better if you can find another way to avoid having to address this issue. If they're SIV eligible, that is much better option. Where it does appear that that USCIS is not digging too deep on adjustment applications, at least so far we've heard. And part of me feels like it may not be a great idea to first try an asylum application. And if you get that denial, then try something else, because it may bring up other questions. Now, on these slides, I went through and I wanted to break out the 4 kind of elements that we came up. And I want to say thank you to Dina, because she did a lot of heavy lifting on this section as she and I worked on this together. And also, we came up with these 4 elements, not that they're ones that the asylum office is necessarily going to be used to seeing, but we did borrow a lot from Charles Shane Ellison, who was a professor, and it's cited in the work, and he's written a much more expansive paper on the Persecutor Bar alone. But we really liked how we separated these things out, because I feel like it's a good way to kind of address the Persecutor Bar as a way of helping you work through what problem to see if you can see if the person is really subject to it. Now, the Persecutor Bar comes from INA 208B to a little I. And really the definition is, anyone who's ordered, incited, assisted, or otherwise participated in the persecution of any person on account of race, religion, nationality, membership in a particular social group, or political opinion. The easy answer is if somebody does something to somebody else and that person could get asylum, then they're probably subject to the Persecutor Bar. Now, looking at this first element here, you have, is what you want to do is when somebody has done something, you really want to ask the first question, what they did, does it really amount to persecution? Because if you can kind of eliminate that from the get-go, you can kind of move on and you don't have an issue. I've listed kind of the various things from the various case law. And by the way, even though there is a definition in the law, this is all largely defined through lots of cases. And we cited a number of cases in the practice advisory. And my sense of it is that I know you may not be able to read them all, but at least hopefully if you're dealing with a specific issue, my hope is at least it can point you to something that might help you out. So these are the ways these are the various acts of persecution. Self-defense is not persecution. There's a case in there that talks about, I believe it was a Bosnian town, where a person was defending themselves from an attack. I think it's a little interesting that we actually had to have a whole case on that, because to me, that seems to be somewhat self-explanatory. Self-defense shouldn't be considered persecution. Someone's attacking you and you're defending yourself. So the first step really is to look at that act and see if it qualifies as persecution. The next element, and I think actually this is one that hopefully you can eliminate a lot of issue, is really as the nexus piece, because you have to have that. So whatever they've done, if it if it is persecution act, if it is an act that qualifies, was it on account of one of the 5 grounds: race, religion, nationality, membership in a particular social group, or political opinion? That's kind of straightforward, but I do think it is important to kind of make that analysis as well. The third one and the fourth one to me is where a lot of, you may get some flexibility in a defense to the persecutor bar. We use the term proximity. I think I always kind of adopted it. That was my word. I don't think you're going to find that in any other cases. A lot of them will talk more about, was there what they did, was it material or integral to what occurred? And the way and this is probably partly because I'm a very visual person, so I try to wrap my head around kind of a visual representation of what I'm trying to say. And it's the idea that whatever they did, is it close in the chain of command, right? Not necessarily were they far away from the event, because certainly someone 3,000 miles away that orders somebody to be killed can be held liable. It's more like in the chain of command or in the chain of events, how close are they to that event? Now, I give you a couple of definitions out of cases. Is it tangential, indirect, or otherwise inconsequential? If they have no direct involvement, that means they didn't actually commit the act themselves. You kind of look at the degree of relation has to the persecution itself, or was the person's role material or integral to that persecution? Now, I threw a couple of examples. These are not ones necessarily out of case. I started thinking about this because a question somebody else had to me, and it actually had to do with somebody who was an HR rep that was in charge of, ensuring that soldiers were moved around or sent to the front or what have you. And there was some concern that they would say, well, could they be accused or be barred because of persecution? And I remember thinking, that just seems so far removed. And I think where I would draw the difference on that is, were they approached to find someone to go do a specific, act that would be found to be barred for persecution, or was it more of a general, hey, I just made sure soldiers were in different places and they may have been used for, certain soldiers may have done certain things or are not. And the other one I was just thinking about was like the idea of a supply officer, someone who, provides materials for someone. And if, they were approached to provide certain torture elements, then, maybe that one could be barred for asylum, whereas maybe they were just to provide water, which also makes me where the term material integral can be a little bit can't always be the best word, because I think, well, everyone's got to drink water and they're providing water, so isn't it material or integral for what they're doing? But that's why I kind of like the idea is that they're somewhat removed. It wasn't, they weren't directly impacting. Now, this is just I'm trying to give people ideas about how they might argue against it. Whether the asylum office agrees with you is another story, or whether the court agrees with you is another story. The third element is really what we call scienter. That's a phrase that shows up in cases, and it means, did they have knowledge, or should they have known that somebody was going to persecute others? And this most often comes up in cases where, and the ones we're going to look at the end, where where someone may have captured someone and taken them back for questioning, and they were tortured through while they were being questioned. And so the question is, did you know, or should you have known? And so that's where it comes up. And if you look at some cases or look at some of the responses, is that they will sometimes look at country reports and go, well, you were part of a certain group and it's well known that you did certain things. So even if you say you didn't know about this, you should have known about it. Let's move on to the next slide. This one's a little shorter. One is you can't, somebody who's in charge of people can't use the excuse of, well, I don't know what was going on, or those are the people under me. I can't, I shouldn't be held responsible. And the case law actually says they are, because they are in authority and they should have stepped in and stopped others. Where also brings up the issue of, will somebody farther down, kind of more your low level people, maybe more people that are maybe a little bit easier to, in a sense that they won't be so subject to the persecutor bar as someone who has a lot of responsibilities. I think it may be very difficult for someone on a higher level that was responsible for a lot of people and was responsible for people who did this, that if they never did anything to stop it, I think it would be almost impossible to not be subject to the persecutor bar. There's currently still no duress exception. The case, we know the Negussi case, but also the current Attorney General has referred Attorney General Barr's case when he said that there is no duress exception. Current Attorney General has referred the case to themselves. We still haven't gotten a response back on that yet. And also just note that federal circuits may vary in finding persecution. So it's important to what particular circuit, your particular circuit, deals with certain aspects of the persecutor bar. Go to the next slide. Or should I go? Can I control it? Oh, here we go. I wanted to now this is kind of my list because these were cases and there's a lot of cases in there, but there were just some language I wanted people to be aware of, or situations where I think was very either interesting or had some great language. So one is matter of DR. That's a great case for discussion of the persecutor bar. It's where the BIA really dives in and looks at many different elements. And we actually cite that a lot in the practice advisory. Then there's also matter of Rodriguez Mahano. The description, it describes certain acts that are typical for war. So they kind of say, well, these are the acts that aren't necessarily persecution. And I also like, there's a language in there, and this is an old case. This is from the 80s. So I'm not sure how useful it may be, but they actually state this phrase: is the persecutor attempting to overcome a belief or characteristic? Because there's a part of me that thinks that might be actually helpful in maybe an argument that someone is not subject to the bar. There's also I like this, and I'm not going to try to say that what this case is, but this is really the Russian Guard who helped capture some women, but then would not participate in the rape of these women. And we talk about this in the advisory, and he was actually punished for this, but it was found not to be persecution. And he was not told, well, you should have done more. Like, he was held not to be persecution. Now, I have a little comment. Rape is a terrible thing, and I hate that I actually am putting this in there. But would a Russian raping other women, would that necessarily meet the nexus requirement? Because you'd really have to, you may actually, and I hate saying this, but you may be able to point out that maybe they didn't rape them because of any of the 5 enumerated grounds. They just raped them because they're terrible human beings. So just something to think about. And then the Miranda Alvarado versus Gonzalez. I always find this one very fascinating because I just think it's very unique. There was an interpreter this is from Peru, and it was the government going after the Shining Path group, and he was there when they were torturing them, but he wasn't actually doing the torture. He was just translating. But they said that his work was integral to the torture. And so he was barred for persecution. And then there's also and actually I misspelled that last case there, but there's a footnote in there that mentions that cutting inmates' hair is not persecution. I want to go to the last few slides because I know I'm running a little short on time here, but I wanted to address the RFE and the NOID that's in back, because those specifically had to do with the persecutor bar. And one is the RFE. I found this one a little bit tougher to make an argument for, but this is a guy that was held various jobs in the government, but while he was a police officer, he did capture people, and they were taken back and supposedly tortured. It also mentions that, he hurt their arms or legs in order to capture them. Now, part of the arguments I thought of, well, you could kind of argue back is, one is hurting someone's arms or legs is part of the war. I've always found that kind of an interesting response. Like, you realize that people are even shot at times as a part of war. So I don't understand why that would necessarily be problematic. I also think is, what did he know, or what is hearsay? Because I think this is important, particularly for a client. Now, they may argue that they should have known. I think it's important with clients to have them just testify to what they did and what they saw. Don't get them into talking about, well, everyone, oh yeah, we all knew that they were tortured, because I think that's a dangerous precedent, because maybe they weren't tortured, but he just thought they were, right? And also I think it's an issue of where were the prisoners sent? Were they just sent back to an area where all the prisoners were, and then maybe certain prisoners were pulled out of the grouping for interrogation? Because then it gets back to the issue of, well, I don't know, my job was just take them, and then they were turned in, and then they went to a prison camp. What happened there? I just, I don't know. And then let's go to the last one, which is the NOID. I actually found that this, when I read this, I thought, man, this was somebody that didn't quite understand the Persecutor Bar, the immigration officer that wrote this out, because they claim that the reason for the bar, and this was somebody that was part of the NDS, the National Department of Security with Afghanistan. It mentions that they persecuted based on political reasons, because the war was politically motivated. That they did stress, they mentioned twice that he killed 30 to 40 Taliban. And that part of the NDS and the NDS has been linked to human rights violations. And then they also mentioned night raids. So my arguments back are that most wars are politically motivated. Doesn't mean that killing the enemy is persecution. So that one kind of, I thought, was really way off. The number of killed is really irrelevant for the most part. I mean, either they persecuted someone or not. Although I guess you can make the argument if it was kind of a one-off scenario, then maybe it isn't part of it. But I did find that I felt like that wasn't really relevant, but it kept mentioning it and annoyed. Membership is not enough. We bring that up in the practice advisory. So just because the person was part of the group does not make them subject to the Persecutor Bar. So that's where it gets back to, what did the person do? What did they really know? What did they see? How far were they from events where that may be considered persecution? Fighting at night is irrelevant. And I'm going to finish with this last thing here. I call this my Band of Brothers defense. I'm a big fan of that show. And if you've read the book that goes to it, these were true events. And in one of the episodes, they go across at night to capture some people, some Germans on the other side. And the event is they go at night, they throw a grenade in. One of the U.S. soldiers went in too quick and ended up eventually dying from his own grenade. But they captured a couple, brought them back. One of the guys was too far gone, and they left on the other side. And he stood there through the whole day, next day, moaning. And it's funny is that when I read some of these noids and I hear that word going at night and capturing people, I go, if you watch that show, I mean, it's something that's held up as something, hey, this is great. And at no time do I ever think that that's persecution. Now, of course, if they took those the captured soldiers back and shot them or tortured them, then it is problematic. But it gets back to the issue of going and capturing people at night and roughing them up along the way and doing your job should not be considered persecution. It's really the other aspects of this. Someone is already now subdued. That's my thing. If somebody's been subdued, then, to do something like persecution is where I think it kind of moves beyond what is normal, what should be considered normal for war. That's all I got. I think I am out. Oh, yes. The noids and the RPs are in the appendix. So.
Thank you, Lance. I just wanted to remind folks that if you have questions, please be sure to post them to the Q&A and we can provide answers live or in written form. And as Lance has just mentioned, the notice of intent to deny, the NOID, and request for further evidence or request for evidence, the RFE, is in the appendix of the practice advisory. And with that, I'll pass it over to Elizabeth.
Thank you, Dina. Yeah, we're going to transition to talking about the serious non-political crime bar to asylum. So this is another mandatory bar that is found in the statute. And I think potentially there's a lot of overlap the Persecutor Bar. So clients that you're concerned about in terms of, past service with military or past service with, intelligence agencies in Afghanistan, you want to be thinking about both the Persecutor Bar and the Serious Non-Political Crime Bar. So this particular bar will apply to those where there is reason to believe that they have committed a serious non-political crime outside the United States. So what we see right up front here is this reason to believe standard, which is pretty low. It's been equated essentially to probable cause. And so there does not actually have to be any type of conviction, right? The testimony from the applicant or other evidence of record, which we'll talk about in more detail in a moment, could be sufficient in certain cases. The crime has to be serious. We rely on case law for the definition of what a serious non-political crime is. Things like murder, terrorism, arson, assault, those are all likely to rise to the level of seriousness. And then we have this interesting inclusion of that it has to be non-political. So we sort of engage in this balancing test of the seriousness of the crime versus the political nature of the crime. So essentially what you're looking at is 3 elements to this particular bar. So is there a reason to believe? Is the crime serious, and is the crime non-political? And we're going to dive into each of these elements and kind of think about what arguments you can make, because if you can win on any of these 3 elements, then hopefully you could defeat a finding that the serious non-political crime bar applies to your client. So the first question we have there is there reason to believe? And as I mentioned earlier, essentially the standard that applies here is whether or not there's probable cause to believe that a crime has been committed. So again, that is a low standard. Certainly an admission by your client can satisfy the reason to believe standard. So if you have a client who in the course of their testimony, admits to murder, assault, human rights abuses, robbery, things of that nature, that's going to be likely sufficient, right? So the asylum office and immigration judge can absolutely rely on your client's testimony to meet that standard, that there is reason to believe. So make sure your clients are, aware of this bar when they're giving their testimony. In the absence of an admission, so there's not always going to be an admission, right? But courts have generally required that there be specific evidence that is available that relates to that particular applicant. So some examples from case law, there's a Board of Immigration Appeals case from a few years ago from 2020 called Matter of WERB that relies on an Interpol red notice that I think essentially, made claims about the applicant being involved in gang activity. There's a case out of the Ninth Circuit that relies on a Guatemalan indictment that provided strong reason to believe the asylum applicant was involved in several murders in the home country, an arrest warrant from the home country. That's a case from the Second Circuit called Kazam. So basically what they're looking at is there's some type of, specific evidence that names the applicant and talks about their involvement in a particular crime. There is a more favorable case out of the Seventh Circuit, and that case, DHS had presented an arrest warrant from the home country claiming that the applicant was involved in drug trafficking, and the Seventh Circuit found that the IJ had erred in relying on that warrant when essentially it didn't even specifically mention the applicant. There was some, incorrect information in that arrest warrant. And so for that reason, it was not reliable. So I would say kind of the common thread in the case law here is that, again, in the absence of an admission, if you hopefully there's no admission by your client as to involvement in these types of activities, courts and the agencies have generally required, reliable evidence that is specifically tied to that particular applicant. So where that takes us is, we're talking about these general reports of abuses by NDS or Afghan military, that, the argument is that is not enough, right? Because it's not specific to our particular applicant. So mere sort of association with that group would not be enough for there to be reason to believe that they committed a serious non-political crime. Okay, so that's kind of prong one, element one here is there reason to believe. Then we get to whether or not the crime is serious. So again, the list of crimes that you would think of as serious: murder, terrorism, typically violent acts like arson, assault, things of that nature. What is somewhat sort of helpful in this context, unlike with the Persecutor Bar, is that the asylum office actually specifically instructs that officers can consider common law defenses to crimes. So they specifically, for example, mention when you're dealing with a children's asylum claim that the officer should consider whether or not the child acted under duress. So that's been helpful, for example, for children or teenagers who may have been sort of forced into something like gang activity where they acted under duress, and that their aid was also a relevant factor because they didn't really have the intent to commit the particular crime. Also knowledge, whether, to what extent the applicant knew that they were committing a crime. So kind of, the basic principles of criminal law. What kind of arguments could you make for your client if they were charged with a crime in criminal court, right? So knowledge, duress, things of that nature. So, sort of analogizing this to our Afghan cases, maybe it's not as much of an issue of children's cases or duress specifically, but again, I think we want to look at the knowledge here, particularly if you're thinking about someone who's maybe, a lower level officer, right? And they're following orders of their superior as to, what type of activity to engage in. That can be generally a defense to criminal liability, right? Unless the order was illegal and the person should have known that it was illegal, right? So just again, keeping in mind that duress and the lack of a culpable mental state can be defenses to this particular bar in the same way they would in a criminal proceeding. And again, I think that's a little bit more generous than the current standard we have for the Persecutor Bar. All right, and then we get to our final element with this particular bar, which is whether or not the crime is political. Right. So again, in order for the bar to apply, it has to be a serious non-political crime. The leading case on this particular topic is a case called Matter of EA from the Board of Immigration Appeals in 2012. So in this particular case, the asylum applicant, he was associated with the government, the ruling party of the government in his home country, and he was sent to an opposition, essentially dressed up as if he were a member of an opposition party to make that particular party look bad to the public. So in doing so, he engaged in things like burning buses, throwing rocks, destruction of food, throwing merchandise off of merchants' tables. No one was ever hurt as a result. And the board found that this actually did constitute a serious non-political crime. So they acknowledged that the crime is, it was actually a political crime, right? It was sort of politically motivated by a political opinion, but they found that the crime was so serious that it was disproportionate to the political nature of the crime. So they didn't actually have to engage in a balancing test. So again, if you have a crime that's really serious, that's really, again, disproportionate to the political nature, that's not gonna save you, right? It doesn't, in that situation, it doesn't actually matter whether or not the crime is political. So again, a lot of limitations to this particular argument. So we're not going to be able to engage in this balancing test at all when the crime alleged is as serious as something like murder or terrorism. And I think there's also a question of how much you as an advocate want to emphasize that this offense is political, because that might open up potentially the Persecutor Bar analysis a little wider, saying that you engaged in this wrongdoing on account of, a political ground or something of that nature. So ultimately, I think this last prong is kind of going to be the hardest to argue about. And I think you're probably going to have more success on elements 1 or 2. So essentially arguing there's no reason to believe if there's nothing specific tying the applicant to a particular act, or that the crime is not actually serious because there's some type of common law defense that can apply, again, like a duress or, following the orders of a commander. So that's sort of where I come down on this one, is I think this last one of arguing that it's political is a little bit tricky. It's not going to help us that much. All right. And I think I will transition into firm resettlement now. And this is when I already saw a question coming about firm resettlement. We've gotten some questions about the practice advisory, so I know this is kind of a hot topic. So firm resettlement is a statutory bar to asylum. It's been in the law since 1996. Before that, I believe it was just in the regs, and before that might have just been sort of a discretionary consideration. So, but it is actually now part of the law that if your client has been firmly resettled in another country prior to arriving in the United States, they are barred from asylum. One really important thing to keep in mind here is that the client has to actually have entered into another country prior to coming to the United States. So if your client has never traveled to a third country, but, theoretically there could be an offer of, permanent residency or citizenship to them if they were to have traveled to that country, then you don't have to worry about the bar. Okay, so they have to actually have entered into the third country prior to coming to the United States. Another important sort of limiting factor to keep in mind here, and this is basically the position of the asylum office and their trainings, is that the applicant has to have been a refugee before they were firmly resettled. So this is actually, I think, a positive framework for thinking about it. And I know that some circuits have disagreed with this approach, but essentially, if your client was firmly resettled sometime way in the past, and then they became a refugee, the bar does not apply to them at all. So let's say, for example, your Afghan client, decades ago received permanent residency in Canada. They gave up that residency. They moved back to Afghanistan. They were living, they were fine there until the Taliban came to power and they became a refugee. They should not be subject to the firm resettlement bar because they were firmly resettled before they became a refugee. So again, just to keep in mind that additional limitation on the bar. Okay, so we will move ahead, and just to flag here the ultimate or sort of maximum confusion about the regulations on firm resettlement. And I know we got some questions about this, which are very good questions. That when you look at the Code of Federal Regulations on the government website, you will see regulations that are actually no longer in effect. So they were part of this so-called death to asylum rule that never went into effect because it was enjoined. But unfortunately, they are still listed on the government website as being the current regs. So again, it makes it very confusing. So I just give a tip here about how you can actually find the regs that govern this framework that we're talking about, which is essentially to look at the regs that were in effect back in December 2020. And that is actually what is in effect now. So again, extremely confusing, but the good news about this is it's a much more positive framework for analyzing the firm resettlement bar, and all the kind of case law that we've developed over the past, decades is still the framework that we use for analyzing this firm resettlement bar. And then the sort of main governing case on this the firm resettlement bar is from the Board of Immigration Appeals. The 2011 decision in matter of AGG sets out this sort of 4-part framework for thinking about whether or not the firm resettlement bar applies to your asylum applicant. So again, I think this is actually like a pretty positive framework for asylum applicants. And the reason I say that is that the first sort of step in the framework is that DHS has the burden of proof of showing prima facie evidence of an offer of permanent resident status. So that initial burden is actually on DHS. So the DHS has to show either that they did receive permanent status in that home country, or that they could have, that there was an offer that was available to them. So if DHS can't make that initial showing, then the inquiry ends right there. You don't even have to get to steps 2 through 4. And then if they do make that initial showing, then we get to the rest of the analysis here. So the asylum applicant has the opportunity to rebut the evidence by showing by a preponderance of the evidence that they did not receive that offer from resettlement, or that they did not qualify for that status. Okay, so that can include showing evidence as to how the law is actually applied and whether the asylum seeker would benefit from the law in the third country. Then the adjudicator will make a determination as to whether the applicant actually was firmly resettled. But even if they were firmly resettled, we still get to the exceptions, and that's step 4. So then the burden would shift to the asylum applicant to show one of the exceptions, which is either no significant ties or restrictive conditions. And we will talk in more detail about the exceptions in a moment. And just the kind of main point I want to emphasize always with firm resettlement is that length of time in the third country does not indicate firm resettlement if there is no offer of permanent resident status. So you could have someone that lived, many years in a third country. That does not mean they were firmly resettled if they did not receive an offer of permanent status there. Okay. I think we can move on to talking about this case. And I did just want to flag this case called Matter of KSE, because this particular case is about about an issue that I know is relevant to Afghans, which is the issue of residency status in Brazil. So we do talk about this case in the practice advisory. So this was a case that was issued in 2020. The asylum applicant was a Haitian national who resided in Brazil prior to seeking asylum in the US, and the board did find that DHS had met its burden of showing an offer of firm resettlement by basically showing that he could have received permanent resident status in Brazil, and he just didn't sort of take one additional step to actually get that status there. And then Mr. KSE tried to argue one of the exceptions, including by showing that he had been specifically targeted for violence because of his race in Brazil, and they still found him subject to the bar. So what's interesting about this case has actually been vacated. It was what is appealed to the Ninth Circuit. The Ninth Circuit vacated the case, and I believe it was also vacated on remand. However, it is still listed on EOIR's website as a precedential decision. Certainly as our advocates, you should argue that because it has been vacated, the case is no longer precedential. But again, I think it's really important to be aware of the case, especially if DHS is trying to argue that this reasoning applies to Afghans who have been, perhaps granted some type of status in Brazil. And the case really does just follow the AGG analysis. And the AGG is certainly still good law. So just be aware that this case is out there, and it's something that you'll have to be prepared potentially to argue against. All right, let's look at a quick example here. So we have Afghan asylum applicant Samira, who lived in Pakistan for 8 years from 2014 to 2022. Samira was undocumented in Pakistan, and she was never offered or obtained any type of permanent resident status in Pakistan. She was later granted humanitarian parole and entered the United States in 2022. So the question here is, was Samira firmly resettled? And I can just give you my thoughts. And if anyone wants to chime in the chat, feel free. But I think the answer here is clearly no, right? And this is kind of the what I was trying to get at earlier, which is that the length of time is not determinative, right? So even if you have someone who's lived in a third country for years, that does not mean that they were firmly resettled if they were never offered permanent residency, as she was not. So we win at step 1 of the AGG analysis, no evidence of firm resettlement in this case. Okay, let's move ahead. I think we just have a couple more slides and then we'll get to questions. So if you're in a situation where the applicant has been firmly resettled, so they have been offered some type of permanent residency status, again, that doesn't mean that you've lost your case. You can argue one of the 2 regulatory exceptions that are laid out here on the slide. So essentially that the conditions in the country were so substantially and consciously restricted by the authority that the applicant was not, in fact, firmly resettled. So we call that the restrictive conditions exception. So you're looking at things like a formal government policy to limit the rights of non-citizen residents, if the refugee's travel documentation has been withheld, if there have been threats or harm by the persecutor in the country of resettlement and the applicant is fearing for their safety. Those can all be evidence of restrictive conditions. So you can almost think of it as, making out sort of a new asylum claim for that third country. And the other possible exception, or, you can argue in addition, is no significant ties. So basically that they entered into the country only as a necessary consequence of flight from persecution, remained only as long as necessary to arrange onward travel, and did not establish significant ties in that country. So this is a very specific, fact-specific inquiry about, whether the applicant only stayed as long as necessary to arrange onward travel. So let's look at a final example, and we can think about a framework for considering this case. So after leaving Afghanistan, Abdul spent several months in Turkey, where he was offered refugee status. Conditions in Turkey were very difficult. He did not have freedom of movement, and he was under constant surveillance by the government. He faced discrimination when looking for jobs and housing. He had no family in Turkey. As soon as he could obtain a non-immigrant visa, he traveled to the US. Was Abdul firmly resettled? So if anyone wants to put thoughts in the chat, feel free. And otherwise, I will say how sort of I would approach this case. So again, thinking about our AGG analysis, the first step is there actually an offer of permanent resident status? So that's what I always encourage you to think about first. It's the facts are he was offered refugee status, but we want to maybe dive into a little bit more into what that means. So you might want to be looking at the laws of that particular country. Sometimes things that are called refugee status are not really what we would think of as refugee status. They might be something more akin to like temporary protected status, where it's really a temporary protection only. So again, don't kind of you don't want to concede upfront that there's an offer of firm resettlement when it's the government's burden to show that there is. So that's one thing that sort of comes to mind here. And then if you do have a situation where the applicant has been found to have been offered a firm resettlement, you want to look at the regulatory exceptions. So I think you can argue both of them here. I think you can argue restrictive conditions if he's under surveillance, doesn't have freedom of movement, he's facing discrimination. And I think you can also argue for no significant ties, right? So he has no family there. He's only in Turkey as long as he needed to arrange his onward travel to the United States. I think these are hard arguments to make, but I would try to make them. And I think with firm resettlement, it's always very fact-specific inquiry, and it depends on what evidence is in the record. So again, even if you have a situation where your client did receive some type of permanent status, you really want to look closely at whether you can argue an exception. All right, and I think that's all I have. So maybe we can transition into questions.
Thank you so much, Liz, and thank you so much to Reena and Lance as well for that summary. I mean, I think we could spend a whole course talking about these bars. I want to turn a little bit to some of the questions posed by some of our participants. We have a question about whether the harm for the duress exception has to be against the applicant in the TRIG paradigm, or whether it could also be against an applicant's family who is still in Afghanistan.
I can try to answer that one. That's a really good question. And so I just went back and looked at the policy memos. So to learn more about each of the TRIG exemptions, you want to go straight to the policy memos and also go to, you can also go to the regulatory exemption of the inadmissibility ground interagency memos as well. But if you look at the one on duress, and it's on the USCIS website, it doesn't specifically say that the duress has to happen specifically to the applicant. It's part of the factors that are considered is whether or not the reasonably perceived threat of serious harm is to the applicant, the applicant's family, or the applicant's community. And the perceived likelihood that the threatened harm would be inflicted based on past instances of harm to the applicant's family, or the applicant's community, or to the applicant. So I would make the argument, and if you have to make that argument, you could say that your client provided material support to a terrorist organization, tier 3 organization, and it was based on duress regarding the likelihood or a threat of harm, the likelihood of harm or the threat of harm to the applicant's family or the applicant's community based on the memorandum on the website. So that's a really good question. So I would say yes, you can take into account the harm to the family member or the duress to the harm to the family member.
I agree. We had another question about any consideration regarding underage marriage. Apparent, one of our participants has remarked that it's a very common issue among the Afghan community that there are instances of underage marriage, and one of the participants has seen annoyed where the serious non-political crime bar was applied because the marriage was deemed to be a crime against human rights. Do any of us of our esteemed panelists like to jump in on that one?
I was going to just say, and Elizabeth, you may have some thoughts on the crime part of it. I just want to point out that there's a lot of materials out there. There's a whole booklet about the issue of date of births in Afghanistan, how they're really untrustworthy. And I had this issue come up with the case, and I kept looking at it going, she was under I think 14 when they got married and then had a kid. And this is a problem. Well, they kind of quizzed a little bit more, and he kept saying, no, she was 16 when we got married, and he knew that. And so the dates of birth, so we had to go forward with kind of guesses on dates of birth. And then I saw materials that have been put out that says outside of Kabul, dates of births, marriage dates, that's, it's not like it is here, of course, where we can go down to the minute or even second when somebody's born. And so you have to, I would really make sure that you kind of go back and really quiz them on, was the date of birth that you put really accurate? And how do you know that that's the accurate date?
That's a really, really good point, Lance. Elizabeth, have you seen anything with regards to, not to put you on the spot, but
no, I had not heard of that issue.
Yeah.
It's actually really interesting. I mean, I see where they're coming from. I mean, I certainly agree on the fact, making sure the facts are correct. I mean, other than that, again, thinking about what would be a defense if this were a criminal case, and then also what is there a potential defense that it's not serious because of X factors, or how old was the individual? I think obviously the younger, then it's going to be more troubling to them. But how would this be classified if this were charged in the US? Would it be considered a serious crime? But I think it is a tricky one, and that is interesting that I hadn't seen that come up before.
Thank you so much. We had another question from a participant asking about offer versus the acceptance of an offer of firm resettlement. And the question is whether an offer is sufficient and need not have been accepted to bar.
Correct. Yeah. And that's what the KSE case is about. But I mean, I think even if you get past the question of whether that's still good law, AGG would say that as well. So you could look at what DHS might do is look to, even if they don't show, okay, you had a green card or green card equivalent or permanent status, that there's a law in effect that you could have obtained it, right? And so I think what you want to look, so yes, offer on its own is sufficient. And then when you get to step 2, you're trying to rebut that by saying, actually, that law wouldn't apply to me, or actually, it's more complicated than you're making it seem. But the offer would be enough for them to make at least that first prima facie showing.
Just so you notice in the Q&A there that thanks Jennifer, she posted the document I was referencing that goes into details about the liability of various documents from Afghanistan. I do think it was very helpful.
Thank you. Thank you to our participant for providing that document as well. There's been some mention throughout about questions about the immigration laws of another country when we talk about firm resettlement. Do you have any suggested resources as to where we can turn when we want to do that research to find out where and what the immigration laws of another country are?
So I guess we cite to a couple in the practice advisory, the country of information reports. I mean, those are helpful, particular for, I think, for Pakistan and Iran, where they talk about like things like birthright citizenship not existing for Afghans born there. Beyond that, I mean, Library of Congress also might be a good resource for folks. They have they have tools on foreign law, and you can also do like an Ask a Librarian inquiry, where you might be able to get some more research done. So that's what I can think of at the top of my head. I don't know if others have thoughts.
I know that way back when I used to turn to Ref World a bit for as a resource. Yeah. That as a potential resource. Are there others that anybody wants to chime in with? And we simply must have tapped into all of the resources, and then there's good old-fashioned Google.
Yes, that works too, for sure.
It's unfortunately where we all start these days. So, something really important here is to recognize that because these cases are more recent, we're all expanding our knowledge on what to expect during adjudication of these cases. And should you choose to, we encourage you to share your observations, your RFEs, your NOIDs, as some of you have done. And you can do that by sharing it with us at afghanresponse@americanbar.org. So again, that email address is afghanresponse@americanbar.org. Again, you can find the practice advisory on the publications page of the ABA Commission on Immigration website, or via the QR code in this presentation. A recording of this webinar will be made available on the ABA Commission on Immigration's Teachable page via the Teachable platform, as well as our YouTube channel. And we have a participant who's actually chimed in to say that Amira is a pretty good but not perfect source for other countries' immigration laws. Thank you so much, Jennifer. That's very helpful. And we can certainly write out that email address to the group. Again, it's afghanresponse@americanbar.org. And Alex, if you wouldn't mind dropping that email address into the chat for the participants, so that folks can have it if they want to share any observations with us, so that we can continue to expand this emerging body of knowledge. We want to thank everybody who has taken the time to attend this webinar, and I want to thank the panelists and the co-authors on this wonderful practice advisory. Again, we really encourage you to use it as a resource. We can't possibly cover everything that's in it in the short period today. And thank you again for attending. Be well.